In our inquiry as to the waste management legal regime, we had a fairly good idea of the international legal developments on that. From that, we move on to the Indian law concerning waste management. In the time constraint that's available, we will not be able to deal with every conceivable aspect of waste management in India, but we shall be able to reflect upon some of the major ones to both understand what the legal regime is about and how it's working. Let us begin with the hazardous waste management law in India. As you could see on the screen, numerous rules and regulations are made concerning a wide variety of hazardous substances waste in India. Quite a good number of other areas of waste are covered, but specifically with regard to hazardous operations, hazardous substances, just to give a snapshot of that, you have the manufacture, storage, and import of hazardous chemicals rules way back in 1989, batteries management and handling rules of 2001, the chemical accidents emergency planning preparedness and responses rule 1996, e-waste management and handling rules 2010, national implementation plan for Stockholm Convention on persistent organic pollutants 2011, the chemical accidents emergency planning preparedness and response rules of 1996, rules for the manufacture, use, import, export, and storage of hazardous microorganisms, genetically engineered organisms, or cells of 1989. Please recall that this last one on hazardous microorganisms, we had an elaborate discussion in the module on biodiversity law. In addition to these, the most comprehensive and significant one on the subject is the hazardous and other waste management and handling rules, including transboundary movement, made in the year 2016. We look to the background of that, its evolution, and the current state of that particular law from now. This law, although it has been in operation the last 3-4 years from 2016, started its journey from 1989, and with periodic changes and amendments is further amended now in 2019 after having been broadly recast in 2016. In fact, most of the changes in the 30 odd years of its life, it has been in response to a number of judicial pronouncements or in response to various commitments that we made at the international level, and to fulfill the same, to come up with a legal regime in India, we have brought in either a new law or has modified the existing one or kept on amending it to keep pace with the requirements of the international commitments and also the demands of the time. Let's just have a look at a few of the interventions of the courts that have triggered reform in the law. The earliest I can record here as something which is of very great significance concerns a public sector undertaking, and this was a decision of the Kerala High Court 1994, the case Law Society of India versus Fertilizers and Chemical Travancore Limited. It's the FACT Corporation, FACT. And what actually happened here, to put it very briefly, this is a decision by the higher judiciary of restraining a giant public sector fertilizer corporation from operating its 10,000 tons of ammonia storage tank in Kochi as a precautionary measure to prevent the devastating impact of accidental leaks from the chemical barrels. By holding that locating a dangerous industrial facility in an urban setting without proper safeguards amounts to putting the very fundamental rights of lives of the citizens at huge risk. Here, it is not the application of any statutory provision, as I was just mentioning, about the hazardous substances or hazardous operations, but actually invoking the highest law of the land, the Constitution, that if you are going to leave something which is hazardous unattended to and keep it in a very negligent condition, as it happened in this particular case, huge storage of ammonia in several barrels and barrels that were leaking despite several requests and demands for taking care of that. Nothing was done, and so there was no alternative for a small group of people, an organization called as Law Society of India, to go to the higher judiciary, the High Court of Kerala, to make a plea that if this is allowed to remain like this, it would be a health hazard and would affect the life and liberty of the people. And right to life is a fundamental right of every citizen of India. And so the Supreme Court, the High Court, invokes this particular provision and then says if any activity which would affect the lives of the citizen and puts it to a high risk, then it is the responsibility of the state to ensure that anybody who is undertaking this kind of an activity, whether it is in public sector or private sector, it does not matter. It should act, control, regulate, and even stop to the extent that it comes in the way of the normal, healthy life of the citizens of India. The next one is a Supreme Court judgment, and this is another research and voluntary group. The case Research Foundation for Science, Technology and Natural Resources Policy versus Union of India, a decision of the Supreme Court of 1997, in which the very attention of the Supreme Court was drawn to a fact, a very sorry state of affairs, of huge quantities of unattended hazardous waste substances thrown helter and skelter, docked in ports all over India, in different ports, and especially in the ports of Bombay, and lying unattended to, even in major cities like Delhi, for a long period of time. Remember, we have made already a law with regard to hazardous substances in 1989, but we are in the year 1997, and to the highest court, the appeal is made, look, your lordships, that we have already a law that's supposed to be enforced, but 8 years down the line, we do see this kind of a terrible state of affairs. Hazardous substances are there, lying unattended to. And it is not just one or few days, for years together. A fact-finding committee was constituted by the court to look into the veracity of the assertions made on behalf of the petitioners. And this fact-finding committee, it's an expert committee, a high-powered one, it highlighted in its report the absence of a proper inventory of such substances lying in different ports. We don't have a proper inventory, how much of it is available, lying without anybody to care for it. And the court notes this with great concern, not just about the poor implementation of the law, but about the irresponsibility of the one who has brought all this to India. putting in various ships and then leaving it unattended to in our ports, and orders for the observance of recommendations of the committee and an effective implementation of the law, which was made quite some time back. The point I'm just trying to highlight here is that from time to time the courts of law have cautioned, warned, reprimanded, and even come up with a set of recommendations based on expert opinion as to how to deal with hazardous substances. First, to apply the law, and second, to follow the superior wisdom of experts so that the hazardous waste are brought under a proper regulatory mechanism and manageable. I draw your attention to yet another huge spectacle of an incident which had international ramifications, and that is with regard to a warship, Clemenceau. It is a decommissioned French warship that was in full play in the Second World War. After decommissioning of it, the ship becomes useless and the ship has to be disposed of. The disposal of a ship is what is referred to as the ship breaking. Ship breaking is an industry by itself, wherein you draw raw materials from that, ready-made iron you will get, and many other parts which can be put to reuse and recycling. A huge industry. And here was this French warship which was looking for a shipbreaking facility. The problem with such ships is it has so much of toxic substance within it that it becomes very difficult for anyone to accommodate that unless you have the skill, the ability to effectively deal with that hazardous substance. And when this ship was making inquiries, trying to get into arrangements for it to be docked somewhere so that it could be safely be disposed of, it went from port to port. Remember, it's a French ship, and from France it is not destroyed or disposed of in France. It goes from port to port, refused entry by Greece, refused entry by Turkey, and then somehow it tries to get into negotiations and successfully at that, and it starts journeying towards Along. Along, you should know, is the biggest shipbreaking industry in the world, and you must know that India and Bangladesh, some of the southern Asian countries, have the biggest ship-breaking industry in the world. 90 to 95% of shipbreaking activity takes place here, and the most prominent one is Alang on the Gujarat coast in India. So they got into a deal, and it was moving towards Alang, and it was in the Mediterranean, and even the Indian government had given approval for that. At that stage, a huge furor breaks out, one both in India and also internationally. It draws a lot of international attention because you have the Basel Convention, there is a Basel ban, as we have already seen. You have the European Union arrangement, which says that any hazardous substance that is produced within the European Union need have to be safely and effectively be disposed of within the European Union, among the European Union countries only, and not to be moved out. There was a clear violation of that. And so is the case with India also. The Indian government, the Environment Ministry gives the clearance. And what assurance of safeguard measures? Not very clear. And so the matter reaches the Supreme Court. The scene is somewhat like this. The ship is in the Mediterranean. It's about to get into the Arabian Sea. At that stage, the matter reaches the Supreme Court of India. The court critiques the position of the government of facilitating violations of both international law and its own regulations. It ordered the prohibition of the entry of this particular ship into India. So it needed court's intervention to then reason into the government that what you sought to do, the kind of clearance that you have given, is in clear violation of your own law, your own regulations, and you should be a lot more careful than, especially when you have something which has international implications. You shall not do this, and you do not have a proper regulatory mechanism to control the shipbreaking activity. And number two, whatever that you have put in place is not adequate. Until you do that, you shall not allow such kind of entry of hazardous substances even for disposal in India. The matter is, if you really look to the story behind that, to complete that story, France, fearing greater diplomatic and international backlash on that, quietly withdrew the ship back to its own port. Now let's just have a look at the salient features of the law that was made in the year 2016 in brief. The description of a hazardous waste under the Indian law. It includes any waste which, by reason of its characteristics like physical, chemical, biological, reactive, toxic, flammable, explosive, or corrosive characteristic feature, causes danger to health or environment, it is a hazardous waste. It comprises of waste generated during the manufacturing processes of commercial products, which includes aluminium, paint, electronic products, and industrial activities that include petroleum refining, production of pharmaceuticals, etc. The law also makes a distinction between hazardous and other wastes that are non-hazardous in nature. The latter would include waste tire, paper waste, metal scrap, used electronic items, etc. The idea is to utilize the non-hazardous aspect of the waste, to use it as a resource to supplement industrial processes and reduce the load on the virgin resources of the country. Like, for example, as I told you, that if you bring iron scrap and we have a recycling industry, and with this iron scrap, with a little bit of a cleaning, this iron scrap becomes iron ready for use. To generate and produce iron, if you subject it to a process, it would be a great strain on the virgin resources of the country, where you have to explore, you need have to really do a bit of a exploitation exercise of taking the ore out, putting it in a furnace, then through a very long drawn out process get the iron out of it. Now you have a ready iron available, which actually helps you in two ways. One is a minimum expenditure of energy and resources, and number two, reducing the pressure on the resources from getting exploited and exhausted in its natural condition. So the idea is essentially a kind of a tightrope walking between, number one, to minimize the adverse impact of the waste, and second, making waste a proposition of reducing pressure on the virgin resources through a process of refinement to be put to use for variety of activities in a recycled way. So waste management hierarchy, in the sequence of priority as you have under this new law, is number one, prevention of production. Number two, when it is inevitable, minimize production. Third, you have produced and you have loads of it available. See how much of it you can reuse, you can recycle, You can recover the original and subject it to a host of processes, what is called as co-processing, and finally safe disposal. This is the hierarchy or the sequence of priorities incorporated in the body of the law. The procedures and documentation for permissions for import or export, filing of annual returns, transportation, etc., which were actually a little cumbersome and had many window clearances, have been simplified and revised significantly with a greater degree of stringency under this new law. The basic need for infrastructure for safe, environment friendly disposal of the waste, the facility for processing, and the standard operation procedures are put in place under this law of 2016. And all these are to be complied by all the concerned, and the State Pollution Control Board, which is made the nodal agency to monitor and regulate this activity while granting authorizations. Co-processing, as I did mention a little while back, as a preferential mechanism over disposal for use of waste as a supplementary resource or for recovery of energy provided here. So this is to keep pace with the changing times of developments in science and technology. Through this particular process, you can recover resource and you can actually transform this into a raw material for energy production. So put that into application rather than disposing it off somewhere. Put waste in one form to different kinds of uses to be of use in different form appears to be the signature tune of this particular law, as well like most of the other laws also concerning waste. Approval process for co-processing hazardous waste to recover energy streamlined, and these are put on emission norms basis rather than on trial basis. So there is nothing like trial and failure and success thing. We give you the permission provided you are going to assure that you are going to conform to the emission norms that are prescribed under the pollution control laws, then you can go ahead with this. Otherwise, no. There is nothing like a trial, because trial, if it leads to failure, would cause so much of damage. So no scope for trials, but on norm basis, are you going to assure? Do you have the expertise? Do you have the ability? Do you have the equipment? Do you have the facility? Go ahead. Process of import or export of waste streamlined by simplifying the document-based procedure and by revising the list of waste regulated for import or export. This was very much necessary. Even this was a little cumbersome earlier. Import of metal scrap, paper waste, and various categories of electronic items for reuse purposes, which had a very free entry into India. In fact, Indians are known to be the past masters in the art of recycle, re-recycle, reuse and things like that, not like the use and throw approach of the Western people. And so every kind of waste used to get into India, and now this is put under serious scrutiny, and unless and until you are able to get the ministry's permission, environment ministry's permission, which would make sure that these are not harmful, we will not allow its entry even into India, no matter whether it would be an income generating, employment generating exercise or whatever. Environmental concerns are paramount, and the health and hygiene considerations take precedence over economics here. States are imposed with responsibility for ensuring their environment's sound management, like by requiring the governments to set up or allocate industrial space or sheds for recycling, pre-processing, and other utilization of them, to register workers involved in recycling, etc., and to undertake industrial skill development activities and ensure safety and health of workers, etc. So, a very bit of proactive measure, something which would be supportive of number one industry and at the same time ensure precautions so that you have the system put in place before you carry on with this kind of an activity of recycling, reusing, or whatever. But all this should come under the frame of environment sound management mechanisms. Clear prohibition. Now you look at this. Not all kinds of waste can come to India, even if it is harmless. Like clear prohibition for import is imposed on items like waste edible fats and oils of animals or of vegetable origin, household waste, tiles for direct reuse purposes, solid waste including PET bottles, waste electrical and electronic assembly scraps, etc. The state government is authorized to prepare an integrated plan for effective implementation of the entire process. State pollution control boards are mandated to prepare an annual inventory of the waste generated, recycled, recovered, utilized, re-exported and disposed. And they are supposed to submit this every year by 30th of September to the Central Pollution Control Board for its perusal and for further needful action. Well, this law has been made just a few years back. These are very early days to ascertain the effective implementation of the new regulations, although there are a lot of apprehensions, there are a lot of concerns expressed by courts of law from time to time, but we can safely assert that the changes affected in the law have brought in a greater degree of clarity, at least in substance, procedures, roles, and responsibilities of different actors in the entire exercise. That much is clear. And industry can no longer complain about hurdles for ease of doing business. They had ease of doing business all the while in an irresponsible way. Now you have ease of doing business in a responsible way. But the necessary infrastructure, equipments, well informed and skilled personnel, and the required preparations at the level of the pollution control boards and in the state governments to ensure effectiveness of the law and its procedures and the mechanisms in place are still in progress. So, with the result that one cannot really say that this is a successful story, but at least an attempt has been made on paper. The results are to be realized with a lot of work to be done by all the concerned. This concludes the first part of this section on the Indian law. The second one under this module would be on biomedical waste regulations. That's the next part of it. Biomedical waste law. This poses a different kind of a problem situation, and this is in relation to hospitals, diagnostic and research centers mushrooming all over, mainly city life, but everywhere in India. Unattended and untreated waste produced during diagnosis, treatment, or immunization of human or animal research activities have always posed problems of health and hygiene. This is quite unlike the huge volume of domestic and municipal waste, which are by and large harmless and biodegradable. The medical waste, they threaten the health and well-being of a large number of population, and if it is not regulated, becoming infectious and having the potential of spreading epidemic diseases. The roots of law on this subject and its evolution over a period of time, like in the previous instances I have discussed with you, lie in a couple of judicial pronouncements. This is very significant. And then, of course, the consequential efforts of the government in dealing with them through notifications under the Environment Protection Act. And I refer to a couple of such case law. The first prominent one is the case of B.L. Vadhera versus Union of India. It's a decision of the Supreme Court of India in 1996. The case starts as a plea for securing instructions to the municipal corporations of Delhi to perform its statutory duties of keeping the streets clean, free of garbage. That's how it started. As the humble beginning of it did not reveal, it ultimately turned out to be a landmark case that triggered making of the biomedical waste rules by the Government of India and later the solid waste management rules in the municipality area. I will come to that a little later, but right now on biomedical waste rules by Government of India. What did the court say? The court gave clear instructions and guidelines to the hospital. I think 14 guidelines were given, and advised the government to evolve appropriate regulations in ensuring the health and hygiene of the citizens are protected. Among these instructions are the insistence on the installation of incinerators and other alternative modes of waste disposal in every hospital which has at least 50 or more beds. If you look to a couple of other cases, you see the state of affairs did not improve much. In fact, even as late as 2012, in another case, and this was a case decided in 2012, the case is Supreme Vastec Private Limited versus State of Haryana. This was before the National Green Tribunal. Government-run hospitals were in focus, and 9 of them in Haryana brought under the minute scrutiny of the Green Tribunal. The Green Tribunal took them to task for the neglect in handling biomedical waste in the prescribed manner. The Biomedical Waste Management and Handling BMWMH rules 1998 incorporated the recommendations of the Apex Court, as you recall, in the Vadhera's judgment. It was amended a number of times, and what we have now is the new Biomedical Waste Management and Handling Rules of 2016, and as amended is intended to improve the compliance and strengthen the implementation of the policy for environmental viability. Let me quickly run through the law as it stands now. What's its object? To reduce infectious or hazardous nature of waste, reduce its volume and extent of production, prevent misuse of waste, ensure occupational safety and health, and to recycle, besides safe disposal. The law covers a whole range of institutions and activities like hospitals, blood banks, nursing homes, dispensaries, veterinary institutions, animal houses, pathological labs, whatever the size is, clinical establishments, research institutions, health camps, medical and surgical camps, first aid rooms, vaccination camps, you name it. The occupier of the premises of these has a primary duty to apply for and secure authorization from SPCB. So whatever the size is, however the extent of your operations are, all these would come under the purview of authorization by the State Pollution Control Board. Here, the wastes are categorized into non-infectious, infectious, and hazardous. So that's the degrees of harm on the basis of which the categorization is done. And this is listed in the schedule with a detailed list under each category. And what is the obligation of the occupier? To segregate at source with personnel trained and equipped to handle them. This is entirely on the occupier. The manner of segregation at source and the process of flow of biomedical waste is in this form: generation, segregation, storage, collection, transportation, treatment, and disposal. All these are detailed in the law. In the amended form that has come just a year back, pre-treatment of laboratory waste, blood samples, microbiological waste, blood samples and blood bags by the occupier are emphasized because this is a huge problem. And realizing it, this amendment has come phasing out of certain items like chlorinated plastic bags, blood bags, or recommended by the WHO, World Health Organization guidelines, and the same are incorporated under this law. And this is something that is to be acted on a priority. Development of a database of all the information concerning compliance with the regulations and maintenance of a web portal in that regard to make them available for scrutiny and verifications are imposed as a very clear, non-negotiable, non-transferable obligation of the occupier. Look at the responsibility imposed on the occupier. He cannot say that I just have let this out premises. They are my tenants. What they are doing, I don't know. You should know. If they are engaged in this kind of an activity, you should not only know, but this is your responsibility. Otherwise, don't allow anybody to carry on this kind of an activity. So, primary obligation is on the occupier in all these situations, as I have just mentioned. Provisions for monitoring compliance, actions on violations, and assessment of compensation payable for deviances made in fair detail. So, a little bit of a teeth is added to the law to make it more effective. Yes, the law on paper appears impressive. The problem is with regard to implementation and compliance, especially by engaging trained, skilled, and well equipped personnel by the enforcers and occupiers. This is less than satisfactory. Further, coordinated functioning among different agencies of state, the health services, and others to help and strengthen the working of the State Pollution Control Board is pretty weak. And in terms of developing information base and updating the same, it is also in short supply. And the law, as you could see, has been frequently changed and modified without giving a fair trial to that which is already in existence and also do a little bit of a performance audit before the next steps are taken. A bit of a knee-jerk reaction to something or the interest in accommodating anything new and everything new into the whole scheme of things. Although it gives the impression of being a dynamic law, it also indicates a strained effort and a knee-jerk reaction besides an besides an attempt in bridging the gap between aspirations and actual results. Well, that is for a beginning as an introduction to the understanding of biomedical waste management.